The pandemic may have changed a lot of things, but it has not changed the need for justice. COVID-19 has ravaged the world. According to IMF's World Economic Outlook published in January this year, the global economy is estimated to have shrunk by 3.5% in 2020. The cliff drop in economic activity meant that the performance of many, if not most, contractual obligations has been disrupted. Regardless of whether force majeure could be pleaded or legislative relief could be relied on, the failure of performance will have triggered claims for debt or damages across the world. In the world of banking and finance where I come from, the impact is nothing short of devastating. A well-known Dutch bank announced in August last year that it will exit all non-European corporate banking activities and completely discontinue its trade and commodity finance activities and close its Singapore operations. Not to be outdone, a similarly well-known French bank announced that it would shutter its trade and commodity finance business in Singapore, sending many of its bankers into the streets. Beneath these Financial Times headlines are real claims for debt owed and not repaid, claims for promises made and broken. So long as there are claims, access to justice must continue. Underlying the need for justice is the user's perception that the rule of law applies in his or her case, and maybe more importantly, until it is decided otherwise, that the rule of law applies in favor of the user. The rule of law is important because it gives certainty to participation in commercial life. It is a proxy for the trust that facilitates human exchange of value, or what we would call economic activity. In the extreme, in order to enter into a commercial relationship, a user need not trust the other party to perform its promises, but the user believes that the rule of law will compel performance, or failing which, impose consequences sufficient to deter non-performance. So where do commercial courts stand given the needs of the users and the importance of the rule of law to them? Ever since the first commercial court was established in 1792 in Paris, commercial courts have been set up in many jurisdictions and are intended to be specialist courts that claim profound expertise to decide commercial matters. Similarly, international commercial courts must claim profound international expertise to decide international commercial matters. From the perspective of users, domain expertise is the hygiene factor. It is only after we can establish this specialism that we can talk about other factors that make commercial courts important to users. It may be useful to briefly compare international commercial courts with what now appears to be the dispute resolution mechanism of choice, arbitration. So what do users of commercial dispute resolution think about when deciding between arbitration and a commercial court? Let me suggest a few. First, expertise, which I talked about. Assuming that expertise is settled, then next comes enforceability. Is the judgment or award easily enforceable, at least in theory? Arbitration has had the benefit of the 1959 New York Convention, and it has taken 62 years to get to where it is today, with 166 state parties. Nowadays, commercial courts can similarly take advantage of the 2005 Hague Convention on Choice of Courts Agreement. But until enforcement of commercial court judgments is as easy as arbitration, it is unlikely to surpass arbitration in popularity. Other factors that have been frequently cited are speed, cost, choice, and confidentiality. Speed in arbitration is oversold, partly because all the good arbitrators are now booked months or even years in advance. And to be fair to the court systems, much improvement has been made using case management tools. In terms of cost, my bank, for example, is paying through its nose in arbitration fees, and I suspect it is not alone. Choice and confidentiality are probably the biggest selling points in favor of arbitration, and something that commercial courts can't do anything about, for very, very good public policy reasons. Which brings us back to the importance of the rule of law to users. Confidential arbitral proceedings do not contribute to the development of law or its harmonization. An ever-increasing complexity in commercial relationships, whether by reason of geography or technology, needs the law to keep up in its development and harmonization. It is by publication that the best minds in the legal world can be engaged, and it is by publication that there can be clarity as to whether the rule of law favors one party or the other. And that is and will continue to be important to the users of the courts. To the extent the commercial courts are able to develop deep domain expertise, deeper than any arbitral tribunal can muster, and the Hague Convention becomes more conventional than the New York Convention, commercial courts will become the first port of call for court users around the world.